This is a 5-alarm code red brace yourself for impact disaster for anyone that cares about constitutional rights. So far, federal courts have been the only half-successful check on President Trump's unconstitutional authoritarianism. And now it seems like the Supreme Court just took away the court's ability to stop the president from doing all kinds of illegal stuff. And the Supreme Court just made your constitutional rights contingent on your zip code. You might recall that in January, President Trump issued an executive order directing federal agencies to stop recognizing the U.S. citizenship of children born to undocumented or temporary status parents. District courts in Seattle, Boston, and Baltimore enjoined the policy, citing a century of Supreme Court precedent affirming birthright citizenship. Their injunctions applied nationwide, prohibiting the government from enforcing the birthright citizenship order against everyone while the cases made their way up to the Supreme Court. However, in a 6-3 ruling, the Supreme Court decided these injunctions, quote, likely exceed the equitable authority Congress has granted to federal courts. So the court granted Trump's application to partially stay the injunctions. As a result, Trump's order is going to become effective in 28 states within 30 days. And without the ability to enjoin the executive branch, it's possible that every illegal thing the president orders will go into effect unless and until the Supreme Court finally weighs in, which can take years, if the Supreme Court even deigns to take up the case. Now, the court insists this is just a procedural fix. Courts can now only block laws within their jurisdiction. But the Supreme Court's decision in this case, Trump versus Casa, means that the same federal policy ruled unconstitutional in one jurisdiction can still be enforced in another. This is going to create a patchwork of federal laws where your rights depend on where you live. A family in Maryland might be protected from Trump's policy because someone went through the time and expense to file an actual lawsuit and their court blocked it, while a family in Texas remains fully exposed to the same law, even if the underlying legal issues are identical. And this decision puts the onus on individual plaintiffs, who often have meager resources to file or join lawsuits to protect their constitutional rights, and do so all the way to the Supreme Court. And it encourages President Trump, with the full backing of the Justice Department, to fight every lawsuit tooth and nail, stalling for as long as possible. And worse, if the administration loses, maybe they just won't appeal. Who cares if it's illegal in one little district, or maybe not even in the full district, maybe just those particular plaintiffs? Fine, there are 93 other federal districts throughout the country, and millions of other potential plaintiffs. Ultimately, this is going to lead to a legal landscape of systemic inequality, and we've already seen what happens when basic rights end at the state line. It was called Jim Crow. But today we're going to break down Trump versus Casa. Now, to understand how we got here and why the Supreme Court's ruling changes so much, we have to start with the basics. Federal district courts have traditionally exercised their equitable powers to enjoin the enforcement of federal laws and policies, not only as to the named plaintiffs, but broadly when necessary to prevent widespread constitutional harm. After all, laws or executive orders apply nationally, so it makes sense that if they're unconstitutional, a court would be able to block their implementation nationally. Now, where did courts get the power to issue such sweeping decrees? Well, from the broad equity authority granted to federal district courts. A court's equitable powers allow the courts to craft remedies that go beyond simply awarding money. They can order people to stop doing things, start doing things, or block the government from enforcing laws. And that's where injunctive relief comes in. And there are several types of injunctions, depending on the stage of the case and the urgency of the harm. For short-term disputes, courts can issue a temporary restraining order, or TRO, which usually expires after 14 days. A court can also grant a preliminary injunction, which preserves the status quo until the end of the litigation. And for a long-term solution, courts can grant a permanent injunction, which is ordered after a final judgment on the merits. Now, Trump versus Casa involved a dispute about just how far these injunctions could go. Nationwide injunctions enjoin the government from enforcing the law or policy against anyone in the country, not just the plaintiffs who filed the lawsuit. Now, there's no specific federal statute that authorizes specifically nationwide injunctions. There's no statute that says they don't have that power. But generally, the power comes from a combination of the Judiciary Act of 1789 and its successors, and the court's equitable powers under Federal Rule of Civil Procedure 65 and the Declaratory Judgment Act. Now, as these sweeping injunctions have become more frequent, they've drawn fire from both Democratic and Republican administrations on pragmatic grounds because they give a single district court the authority to stop the implementation of a national policy. And certain litigants figured this out, so that led to forum shopping, where litigants strategically filed lawsuits in districts where they know they would get a favorable judge for their cause. And this problem was best illustrated by Judge Matthew Kacsmaryk, the only judge in the Northern District of Texas Amarillo Division. Now, after the Supreme Court reversed Roe v. Wade, anti-abortion litigants flocked to Judge Kacsmaryk's courtroom, because they know how he would rule on those issues. In 2023, Kacsmaryk issued a nationwide injunction blocking the FDA's approval of the abortion drug known as mifepristone. But the plaintiffs there were guaranteed to get Judge Kacsmaryk because he was the only judge in that area. And coincidentally, on the same day, Judge Rice of the U.S. District Court for the Eastern District of Washington granted a broad injunction enjoining the FDA from changing its guidance on mifepristone. Judge Rice's decision applied to 17 states and Washington, D.C. Now, these dueling injunctions created confusion and chaos, and all this happened before the courts had opportunity to rule on the merits after a full briefing and argument. But in either case, very few people argued that the solution was no nationwide injunctions. The solution was obviously don't have a division where only a single judge is sitting, so the plaintiffs were guaranteed to get a right-wing whack job. But while nationwide injunctions were an important tool to check federal power and unconstitutional moves, judges also had the ability to abuse their injunctive powers. But that's why the limits placed on injunctions were so important. And it all started with the legal standard for obtaining an injunction. Judges are not supposed to hand them out like candy. A preliminary injunction is an extraordinary and drastic remedy, and to get one, a party has to show they will suffer irreparable injury if the court doesn't act before the case is resolved on the merits. And the injury typically has to be something more than just loss of income or money. And because they're so coercive, courts are supposed to tailor injunctions to be no more burdensome than necessary, just enough to give complete relief to the parties in the case. But the practical reality is that nationwide injunctions were increasingly polarized. A study by Harvard Law Review concluded that nationwide injunctions are becoming more frequent, and they are, quote, overwhelmingly issued by judges appointed by presidents of the opposite party from the administration whose actions the judges are enjoining. Of the 78 nationwide injunctions issued during the Trump and Biden administrations, 93.6 of the injunctions were issued by judges appointed by a president of the opposing political party. But if you're going to sue the Trump administration, you're going to want a good lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've got in a car crash, suffered a data breach, especially if you've got a data breach letter saying your information might have been leaked, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. And that brings us to Trump versus CASA. Now, as Liz Dye explained on the channel earlier this year, for over a century, anyone born on U.S. soil has automatically been given citizenship, regardless of their parents' immigration or citizenship status. Birthright citizenship is rooted in the 14th Amendment, which guarantees all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. And the 1898 Supreme Court case of United States versus Wong Kim Ark established birthright citizenship for children of all immigrants. It is considered a bedrock principle of constitutional law. But while denying citizenship to children of immigrants was once a fringe position, it is now the official policy of the Republican Party. Here's President Trump explaining that the 14th Amendment only conferred citizenship on children of enslaved people.
That was meant for the babies of slaves. It wasn't meant for people trying to scam the system and come into the country on a vacation.
And so on January 20, 2025, President Trump issued an executive order excluding certain children of non-citizens born in the United States from birthright citizenship. Plaintiffs impacted by the executive order filed several lawsuits. The courts enjoined Trump from enforcing the order because it was very clearly unconstitutional. And in this case, the Trump administration did not ask the Supreme Court to overturn Wong Kim Ark because the court probably wouldn't do that. At least that's what we think now, check back in a year. But instead, Trump asked the justices to limit the scope of injunctions entered by the lower courts because they do not have the power to grant relief to plaintiffs who were not included in the lawsuits. In response, the plaintiffs argued that, quote, being directed to follow the law as it has been universally understood for over 125 years is not an emergency warranting the extraordinary remedy of a stay of the injunction. But Trump argued that, quote, years of experience have shown that the executive branch cannot properly perform its functions if any judge anywhere can enjoin every presidential action everywhere. Now, the court consolidated the three cases, but explicitly did not rule on the constitutionality of birthright citizenship. And in a majority opinion authored by Justice Barrett, the majority considered only the procedural issue. And the court held that the injunctions, quote, likely exceeded the equitable authority that Congress has given to the federal courts under the Judiciary Act and Rule 65. So the justices granted partial stays of the district court orders, limiting them to what's necessary to give the plaintiffs before the court complete relief. And in reaching that ruling, Justice Barrett considered the meaning of the Judiciary Act of 1789. Quote, universal injunctions were not a feature of federal court litigation until sometime in the 20th century, and they remained rare until the turn of the 21st century. Which is true, but first of all, the nature of power between the executive branch and the legislative branch has changed over time. Congress used to be able to, do stuff and pass laws, and now for various reasons it can't. So presidents, mainly starting with George W. Bush, continuing with President Obama, Trump, Biden, and now Trump too, started relying extensively on executive orders for more and more things. And secondly, when you're dealing with a true authoritarian president who everyone agrees signed an incredibly unconstitutional executive order, which is not law, that abrogates birthright citizenship as well as a whole bunch of other completely unconstitutional executive orders, it really seems like the default position should be for federal courts to temporarily enjoin that during the course of the litigation. These are executive orders where there isn't a single American for whom the executive order could be legally enforced. And it really seems like Barrett's opinion is originalism motivated to get to a specific outcome. Since nationwide injunctions did not exist in 1789, the courts do not have the power to use them now. And the majority held that, quote, because the universal injunction lacks a historical pedigree, it falls outside of the bounds of the federal court's equitable authority under the Judiciary Act. Now, I find this reasoning to be extremely unpersuasive. This gets into some technical legalisms, but first, federal judges' power comes from multiple statutes or laws that have been passed over time, as well as the Constitution itself. Now, originalism theoretically seeks to divine what lawmakers intended the law to mean when it was passed. And when you're interpreting statutes, you generally don't look to English common law, because who cares what happened in English common law, because we passed the friggin' law to pass the law. So you look at the law itself. Now, second, Barrett is just dead wrong on the history. When you look at the common law and the courts of England, you see that equitable remedies were always intended to be flexible to right wrongs that courts of law couldn't address. And on top of that, really, for technical reasons, the distinction between courts of equity and courts of law doesn't really even matter in modern American courts. But as Justice Sotomayor points out in her dissent, courts of equity in England often decided issues for interested parties who were not party to the actual suit before the court. That was Barrett's main concern, that the universal injunctions bind parties who were outside of the actual litigation itself. But third, in any event, equitable remedies are the original flexible remedy. And as I mentioned, the nature of the executive has changed over time, and it makes total sense that the nature of equitable remedies would expand to address the expansion of executive power. But a lot of what the majority talked about was in terms of what was necessary for complete relief for the plaintiffs. The plaintiffs here argued that they could only get complete relief from the unconstitutional policy if the injunctions applied to everyone. Justice Barrett disagreed. Quote, prohibiting enforcement of the executive order against the child of an individual pregnant plaintiff will give that plaintiff complete relief. Her child will not be denied citizenship. Extending that injunction to cover all other similarly situated individuals would not render her relief any more complete. And although the plaintiffs argue that universal injunctions, quote, give the judiciary a powerful tool to check the executive branch, Justice Barrett countered that checking the executive's power was not a legitimate consideration in this instance. Quote, federal courts do not exercise general oversight of the executive branch. They resolve cases and controversies consistent with the authority Congress has given them. Yeah, but the judiciary's branch is to interpret the laws, determine what's constitutional, and stop the executive from doing unconstitutional stuff all the time. And if the executive does something that's illegal and unconstitutional with respect to 10 million people, and you only enjoin them from putting that into effect for 2 people, then it's kind of a Pyrrhic victory. But the thing is, in these cases, the government is a party to the litigation. Why can the federal court not enjoin that party who's before the court and stop it from taking an action across the entire country? And as we'll talk about, Justice Kavanaugh's solution is that it's just going to be the Supreme Court that deals with these issues on the shadow docket. But if we're really going to go down this legal rabbit hole, if the lower courts can't issue a universal injunction, why would the Supreme Court be able to? And why would the executive be bound by the Supreme Court's decision outside of the very litigants who are in front of the court? Because the upper and lower federal courts share the same source of authority. And of course, it's very suspicious why the Supreme Court didn't address this issue during President Biden's term, when district courts routinely issued nationwide injunctions that halted his COVID policies and student loan programs. For example, in the past, Justice Gorsuch has been the most outspoken opponent of nationwide injunctions, and yet he affirmed universal injunctions against the Biden administration at least 10 times, according to research by Professor Steve Vladeck. In any event, as it stands now, the executive order will become effective in 28 states within 30 days. The children it targets will be American citizens in 22 states where lower courts block the order, but newborn children in the other 28 states will be basically stateless unless some plaintiffs in those districts are able to quickly file legal challenges in every jurisdiction. And unfortunately, the Supreme Court doesn't give the lower courts a clear roadmap for how they are determined what constitutes complete relief. Must plaintiffs file lawsuits in all 50 states and the District of Columbia in order to ensure that every newborn to foreign parents becomes an American citizen? And what if the Trump administration challenges the scope of the injunctive relief in some of those states? The appellate courts are bound to follow Trump versus Casa, so they could stay the injunctions while Trump makes his legal arguments. And during that time, Trump could continue to inflict constitutional injuries on plaintiffs all over the country. So this is not a recipe for judicial efficiency. And critics of this decision point out that this fracturing is exactly why nationwide injunctions are sometimes necessary. They prevent a patchwork of different laws and to eliminate costly and duplicative litigation. But the answer of the majority in this case is that plaintiffs should file nationwide class action lawsuits. And this could be a semi-reasonable workaround. But it also assumes that the Supreme Court allows them to go forward when it has been extremely hostile to class actions for some time. But at base, to get a nationwide injunction, plaintiffs will now have to go through the somewhat rigorous class certification process. To certify a class action, plaintiffs have to satisfy all 4 requirements of Rule 23, and moving for Rule 23 class certification is both a fact and legal issue, which is why moving for class certification usually comes after discovery in most cases. But to do so, first plaintiffs have to prove that there are so many people affected that it's impractical to sue individually. Second, there must be questions of law or fact common to the class. Third, the lead plaintiff's claims must be typical of the class. Basically, their story has to represent the group with no outliers or special treatment. And fourth, the named plaintiffs and their lawyers must be ready to fairly and adequately protect the interests of the class. So that means no conflicts of interest and other things. So going the class action route is at best an impediment, and at worst, a huge procedural roadblock that could waylay a lot of these cases. And you can argue this is a good thing, but the practical reality is that the Supreme Court is tightening the rules for nationwide class actions at the same time that they're going to make it easier for the government to blatantly violate people's rights. And it really seems tone deaf to what this particular administration is doing in reality. And of course, during oral argument, Trump's Solicitor General, John Sauer, said the administration would fight class certification on nationwide classes. Meanwhile, Justices Alito and Thomas filed concurring opinions, warning district courts to strictly apply the rules governing class actions. Quote, lax enforcement of those requirements for third-party standing in class certification would create a potentially significant loophole to today's decision. And in a concurring opinion, Justice Kavanaugh proposed another solution for the problem of patchwork rights, just asked the Supreme Court for more guidance. Kavanaugh recognized that it's important for federal rights to apply uniformly to everyone, but he says it's only the Supreme Court that should be the ones that make that call. He writes, quote, this court should not and cannot hide in the tall grass. When we receive such an application, we must grant or deny. He says the court's decision will often serve as, quote, guidance throughout the United States until the issue is finally resolved. I mean, sure, plaintiffs would definitely welcome swift decisions on these major constitutional issues, especially one that's as clear as birthright citizenship. But the Supreme Court actually had discretion to consolidate all the birthright citizenship cases and decide them on the merits if it wanted to. Had the court done so, all of the future litigation that we've been talking about would have been avoided. But instead, the court chose to make the procedural rule that invites future court inventions. Kavanaugh is inviting Trump and his critics to use the court's emergency docket even more. So one way to look at this ruling is it's giving way more power to the executive, while at the same time amassing more power for itself, elevating it even more above the lower district courts. Now, the 3 dissenting justices said the decision was a setback for civil rights in some of the most scorching language I've ever seen. They said that nationwide injunctions were essential to protect constitutional rights on a broad scale. Justice Sotomayor focused on the legal standard for granting injunctive relief. She asked, quote, what grave harm does the executive face that prompts a majority of this court to grant it relief? The answer, the government says, is the inability to enforce the citizenship order against non-parties. For the majority, that answer suffices. See, for example, when a federal court enters a universal jurisdiction against the government, it improperly intrudes on a coordinate branch of the government and prevents the government from enforcing its policies against non-parties. The problem, however, is that the executive branch has no right to enforce the citizenship order against anyone. As the executive itself once put it, the order is unquestionably unconstitutional. It defies logic to say that maintaining a centuries-long status quo for a few months longer will irreparably injure the government. The issue, the perceived injury to the Trump administration, is a theme that Justice Sotomayor has raised in several recent dissents. And she explains yet again how dubious this analysis of harm really is. Quote, the majority's contrary position is self-refuting. Suppose an executive order barred women from receiving unemployment benefits or black citizens from voting. Is the government irreparably harmed and entitled to emergency relief by a district court order universally enjoining such policies? The majority apparently would say yes. Justice Jackson wrote separately to say, quote, today's ruling allows the executive to deny people rights the founders plainly wrote into our Constitution, so long as those individuals have not found a lawyer or asked a court in a particular manner to have their rights protected. This perverse burden shifting cannot coexist with the rule of law. In essence, the court has now shoved lower court judges out of the way in cases where executive action is challenged, and has gifted the executive with the prerogative of sometimes disregarding the law. As a result, the judiciary, the one institution that is solely responsible for ensuring our republic endures as a nation of laws, has put both our legal system and our system of government in grave jeopardy. So now what? Well, within hours of the decision, several groups in this case filed a nationwide class action challenging the executive order. This all but guarantees that the Supreme Court will have to decide a major case on whether nationwide classes should have been certified. And then we'll find out whether the Republican justices will interpret the rules to allow nationwide classes in cases like this or not. And do we think this particular court, based on its Trump-positive jurisprudence, will make it harder or easier to certify nationwide class actions? Who knows? And honestly, I don't know if this is a nothing burger or the end of judicial review of the executive. But this shows why it's so important to get accurate legal information from news sources that you can trust. For example, you can see that the story we're discussing today was covered by over 130 sources, with 13% coming from the left, 56% from the center, and 31% coming from the right. And the differences couldn't be more stark. On the left, sources say that the court's ruling on universal injunctions was absurd, furthering the country's plunge into authoritarianism. In the center, sources largely focused on explaining what the ruling means for legal challenges against the administration or Trump personally, and on the right, sources celebrated the big win with headlines like "another one bites the dust," because headlines and coverage vary greatly depending on the source. And that's why I love today's sponsor, Ground News. The Nobel Peace Center called Ground News an excellent way to stay informed, avoid echo chambers, and expand your worldview, and I couldn't agree more. Because Ground News gathers related articles from around the world and across the political spectrum, so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. One of my favorite parts is their bias comparison feature, which highlights specific differences in reporting across the political spectrum. And I also love their blind spot feed, which shows you stories that are underreported by either side of the political spectrum. But all this is why Ground News is my favorite way to get the news. And as a legal eaglet, you can save 40% off the Ground News Vantage subscription by scanning the code on screen or clicking the link down below. This subscription gives you unlimited access to every feature, including the Bias Insight tool and the blind spot feed. So sign up for Ground News now, and after that, click on this link over here for more Legal Eagle, or I'll see you in court.